Welcome to Politics Today on ITV Network. In today's program, we'll keep tabs with some of the trending stories in the political scene. A major talking point will be the recent development with the Osun State Supreme Court judgment on the governorship election in that state. We'll also be linking up with chairman of Labour Party in Edo State to give us his perspectives on the recent court ruling on the Labour Party leadership tussle. My name is Sonny Duke Osun. Welcome on board the program. Let's get started with some of the trending stories in the political scene. With just 17 days to the end of his regime, the president, Muhammadu Buhari, has moved out of his official residence. We hear that he's moved to the residence that is usually reserved for outgoing presidents. And that's to give room and space for some tidying up to be done. That way, the incoming president will have a freshness, so to speak, in the Aso Rock Villa to take over the mantle of leadership. Well, we're not expecting some of the major construction work to be redone in the Aso Rock Villa. Maybe we could have some paintings here and there, as is always the case, just to ensure that some of those stains and some of those little things that haven't been taken care of, they are taken care of, just to sensitize and sanitize the system. And it's good enough for the incoming administration to enjoy the Aso Rock Villa. Of course, you know, that's the seat of power. That's the place where the president of the Federal Republic of Nigeria is staying. So with just 17 days to the end of his regime, President Muhammadu Buhari has finally moved out of his official residence inside the Aso Rock Presidential Villa to the glass house, a temporary structure that has served as the abode of outgoing presidents since 1991. The move is to allow for maintenance work on the residence in preparation for its next occupant, President-elect Bola Ahmed Tinubu. Most of Buhari's aides have also been moving their personal belongings out of the seat of power in order to create room for Tinubu's personal aides and the key presidential officials. On the nature of renovations in the main residence, a senior state house source said the 32-year-old edifice was being coated with white paint, while some of its sections were being cleaned and fumigated. Okay, the seeming crisis or brewing crisis as it relates to the leadership of the National Assembly is still on, with hundreds of northerners who conversed on the Arewa House, Kaduna on Friday, have threatened to withdraw support for the government and the ruling All Progressives Congress APC unless the North is given the leadership of the National Assembly and other ministerial appointments. The Northerners attended a one-day roundtable on nation building and democracy with the theme, the imperative of participation, equity, and equitable development of Northern Nigeria, powered by the Democratic Research Institute, DRI. Okay, the rift within the upper echelons of the People's Democratic Party, PDP, appears unresolved as 5 governors under the aegis of the G5 were conspicuously absent at a meeting of the party's presidential candidate, Alhaji Atiku Abubakar, with his deputy vice presidential candidate, Ifeanyi Okowa, with current and soon-to-be inaugurated governors. So it means there is no end in sight for the crisis that rocked the party before, during, and even now, after the election. Okay, let's go to our last story before we quickly have a chit-chat with Kelly OGBALOI, the Labour Party chairman in Edo State. The story is that the High Court of Justice of the Federal Capital Territory, Abuja, has assumed jurisdiction in the suit filed by some aggrieved members of the Labour Party against the suspended national chairman of the party, Julius Abure, and 3 others. In his preliminary objection filed by the National Chairman, Julius Aburi, and the National Secretary. They are challenging the jurisdiction of the court to entertain the matter. The suit is based on the order restraining the Aburi as well as the National Secretary Alhaji Farouk Ibrahim, National Organizing Secretary Oluchi Okbara, and National Treasurer Clement Ujuku from parading themselves as leaders of the Labour Party pending the hearing of a suit seeking their sack or allegations of fraud bordering on alleged forged court documents, including receipts and seal of the court, which they had allegedly used in the substitutions of LP's candidates in the 2023 general election. Justice Hamza, while delivering the ruling on the application, held that the court has jurisdiction to hear the matter, adding that the plaintiffs were right to have brought the originating summons before the court. The case has been adjourned to May 17 for the hearing. Now we'd like to quickly have a phone conversation with Comrade Kelly OGBALOI, Edo State Labour Party Chairman. Comrade Kelly OGBALOI, thank you for joining us on the program Politics Today.
Thank you so very much, Duke. I'm happy that you are taking this now. I am glad to be with you.
Thank you. With the Federal High Court affirming its jurisdiction to entertain this matter, on the streets, there is a contrary view on this issue. I mean, I've heard people say that, well, the LP national chairman finally has been removed by the Federal High Court. So what is the substance in this matter brought before the court, and what is the position of the court from your perspective?
Well, to say that National Chairman Barrister Julius Aburi removed is a blatant falsehood. That was not the pronunciation from the court. For the news you just relayed, clearly the issue of jurisdiction was before the court, and the court assumed jurisdiction eventually. As a matter of fact, it was in their wisdom. It is not for us to say you shouldn't do it, but that has been contested. But to come out by the renegades, Papa and other, to say they be confirmed as a substantive chairman and officials of Labour Party is not correct, because that pronouncement was not made from the court. But let us expand a bit. There was an expert motion expert from the same court, which ordinarily restrained the national chairman, from the activity of the party. And then, if I'm not a lawyer, but if we have a big idea of what an expert motion is expected to be, it's an element of a command for the court or another from the court, made to ensure that a perceived delicate situation is not allowed to happen for a period of time. And for what we know is that it should not exceed 14 days. Okay. But in the case of Justice Muazu, his interpretation from it is that an ex parte motion can persist, unduly to the distant future. And this is what we have seen. But I can tell you that even at the point of assuming jurisdiction, the party has decided or filed his papers to move ahead with an appeal. So I made clear that the national chairman of Labour Party, Barrister Julius Aburi, is the chairman of Labour Party. He has not been removed, and that pronouncement was never made for the courts.
Okay, that seems to be the line of action by the Labour Party headed by Barrister Julius Aburi. I mean, from your own perspective.
That is the only Labour Party that is existing, sir. There is no other Labour Party anywhere.
Okay, there's a feeling in some quarters that your party is feeling dissatisfied with the way this matter is being handled, specifically under Honorable Justice Muazu. Exactly.
That is why it was part of my explanation to you now that we are dissatisfied because the undue extension of the ex parte motion in order to perpetrate the restraining order is not satisfactory to us. Okay. We also feel that it does not have jurisdiction to entertain the matter. Okay. And so if in his opinion he feels he will assume jurisdiction to entertain it, we want to go and ask from the appeal court whether he is correct or not.
Okay, so we'll keep our fingers crossed and see how all of this plays out in the days to come.
Thank you very much, Duke. We appreciate you.
Thank you very much, Comrade Kelly OGBALOI, Edo State Labour Party Chairman. Thank you so much.
Thank you. Thank you. Thank you.
It's still politics today. We just had a chat with Comrade Kelly OGBALOI, Edo State Labour Party Chairman, on the Federal High Court ruling on the leadership tussle rocking the Labour Party as it relates to the jurisdiction of the court to entertain the matter. But the judge in his wisdom has affirmed its jurisdiction, and the plans, according to him, is to seek redress at a higher level, or possibly go to other levels of courts just to seek redress because they feel dissatisfied with the way and manner Justice Mazu is handling the matter. Anyway, that's on the side. Let's quickly get back to our panelists here in the studio to give us their perspective on this before we zero in on our major talking point on the show. I'd like to thank very especially the immediate past chairman, the Lion Bar Edo State, Benin Branch Association of the Nigerian Bar. Thank you so much, Barrister Passoy. Thank you for coming.
It's my pleasure to be here.
We also have with us here another lawyer. Well, this wasn't planned for, but it's a good one. Barrister Sonny Daudu. Thank you so much for joining us.
Thank you very much.
Okay, let's quickly look at what has been brought forth on the High Court ruling or order. I don't know what you guys call it, as it relates to the leadership tussle about an ex parte motion and its lifetime. Let me get to take it. Let me begin with you, Barrister Oiwo.
Well, just as you have rightly observed, and I think we listened to the state chairman of the Labour Party talk to us just a few minutes ago. An ex parte application is such that just one side is hard. Someone bringing an interim, bringing an application just for the purpose of seeking the relief of the court, an interim order of the court, which normally by laws lasts for just 14 days. And then it is normally done in situations of urgency.
Okay.
And the courts have also been warned and advised by the National Judicial Council, the NJC, which is a body statutorily empowered to appoint and discipline judges, to be careful about granting ex parte orders. In this particular case, I really sympathize with the Labour Party over the kind of order that was made by the Federal Capital Territory High Court, which will tend to create a kind of problem for the party, because you begin to see a situation where people just stand up just without following the due process, without complying with the constitution of the party, and then they just approach a court for one reason or the other. Then they are able to secure an order that is made ex parte. Well, when an order is made ex parte, it is nonetheless expected to be served on the other side, who has an opportunity to come and argue the main application, which is the interlocutory application. That application is now affords the opportunity for the other side to be heard, and then to also give the court an opportunity to do a balance of the issue and the matter that has been brought before it. And in this particular case, I think that the Labour Party leadership, which Comrade Kelly OGBALOI has talked about, our brother Mr. Abure, has properly, I believe, filed a counter affidavit to the application filed by the other side, by a Papa-led faction. And when that is done, of course, the court is then expected to consider the merit or otherwise of the initial application that was brought, because it is the same application that is brought by way of ex parte that is now considered for the court to determine whether or not that order that was made ex parte without the other side hearing being heard is or ought to have been properly made. And when that is done, of course, the court now decide whether or not to go into the, of course, the opportunity and the stage will now be open for parties to be heard in the main case itself, which is the main trial. And in this particular case, it is an originating summons that was brought before the court for interpretation of the law as to whether
the court has jurisdiction or not.
And when the court rules in such a manner, of course, like the Labour Party led by Comrade Abure has, through their spokesman now, the chairman of the state, had talked about, they intend to explore the avenue of going on appeal. Of course, a jurisdictional issue like they have canvassed, challenging the decision of the Federal Capital High Court decision, is one that can, of course, be looked at also by the appellate court.
Okay.
And this time around, the Court of Appeal.
Okay.
And it is within their right to do so.
All right, Mr. Sonny Daud, let me get your take on this, particularly as it relates to the issue of the timeline for an ex parte motion, which is something that the Labour Party chairman talked about as one of the misgivings from them as it relates to the disposition of the Federal High Court Judge Muazu. Yeah.
Well, thank you very much. Ordinarily, an ex parte order lasts for 14 days, but it is not determined immediately. The reason why it lasts for 14 days is to allow the application for interlocutory judgment to be heard. But in this wise, the preliminary judgment brought elongated it. There was a plenary objection from the Abure-led faction that the court itself has no jurisdiction to entertain the matter. While all these things are ongoing, any other thing remains in abeyance. The order will subsist. The interlocutory, the interim injunction given by the ex parte motion will subsist until all of these issues are determined.
Okay.
So the implication is that by the mere fact that it ought to last for 14 days does not extinguish if the interlocutory injunction has not been heard. Because again, the court can extend it. The court can extend the ex parte injunction to remain in force pending when the interlocutory application is heard, so that the both parties can, of course, canvass their position.
Okay.
But this has not been done in view of the fact that a plenary objection was brought. And the position of the law is that once a plenary objection is brought to the court must first of all hear the plenary objection. Hence, the interlocutory application is still pending. They have also filed their counter to that interlocutory application and the main suit. So the question now is whether or not the interim order extinguished. The answer is no, it has not extinguished, even though, of course, it ought to last for 14 days. So the only fear I have, is whether or not ab initio, Abure and the other persons, so they challenge their alleged suspension by the faction that suspended them.
Okay. Because
we have a precedent, and because was of the view that it is not enough to say the person who suspended you do not have the power to suspend. The question is whether or not you challenge the suspension of grounds that the person doesn't have power.
Okay.
So if you do not challenge it ab initio, then the principle of whether you acquiesce or concede to that suspension may also be canvassed at all levels of
so
the matter.
If it was challenged,
if it was challenged,
yes,
it means ab initio that the man disagreed that the people who suspended does not have the power.
Okay.
And that, of course, will form the fulcrum of the argument as to whether or not the ward executive has the power to suspend a national chairman of the party. Okay. And if you look at it arguably, they do not have the power. But if you don't challenge it, it means it subsists that you did not.
Let me just quickly see if I can link up with Comrade Kelly OGBALOI. Comrade Kelly, good morning. Are you still there?
Yes, I'm here.
Okay, so a fundamental question has arisen from this conversation, which has to do with whether or not the suspension was challenged ab initio to give rise to your party chairman laying claims to being the chairman of the party. Yes.
Well, I may not be exactly sourced on this.
Okay.
But ordinarily, the legal department of our party was not asleep. I can tell you that yes, there was a challenge, except I'm not confirming that now.
Okay.
And what I think has happened really was these things were pari passu. There was an ex parte restraining him, and then within the very close time, these ones now ran themselves into the National Secretariat in the absence of the National Chairman, broke down the office and as a matter of fact, announced themselves, about 5 or 6 of them, to say they have taken over.
Okay.
So upon that now, we have to battle with how that order itself will be vacated, which persists up to today. But I think I can come back to you to be sure of what was done, in challenging the issue itself much later.
Okay, what is it about the talks that these crises rocking the party is the handiwork of detractors who wants to, at all means, scuttle the party's efforts at the Presidential Election Tribunal? Of course, we know that is already in court, but we're not talking about the what is happening at the tribunal. But the talks that all that is happening is just to scuttle the party's efforts at the tribunal, as it were.
Yeah, that cannot be taken away, and I'm sentimental about it, that it's happening, because it's not happening. A sensible political party with the level of Apapa and others who are doing this yeoman's job would have understood from the beginning that this is not the time to fight internally, because we have a major matter in the court, and this matter we have in the court has an effect on the generality of the persons in Nigeria, because we are yearning for a good country now. We are asking that a better Nigeria is possible. So why will on earth this kind of persons come together and say, oh, we are fighting ourselves eternally over nothing? So I won't take away the fact that there are external forces trying to be part of what is happening to us. And from the recent utterances of Apapa, you found out that they were just using this to be reasons why they will go and support some other means of outside there. Apapa has recently told us that, of course, the swearing of the other person from the other political party must not be disturbed. So why is it now trying to speak for those political parties? Why is it his duty to make position for all of that? So for me, major part of the problem we have is the incursion of other political parties wanting to bring us down. Because today, Labour Party is the only party that you need to beat. Of course, the others are almost gone now. And so, the ruling party does not want such, ability, in any political party to contest anything with them. And this is what is going on.
Okay, quickly, there's been a talk that what is playing out now could just be something that has been there all along, but it's now been blown into the open. That the party has always been, bogged down by this crisis, but it was being managed, up until after the election. Then everything is in the open.
Yes, yes. If nobody, not quite a lot of person would accept the progress of anyone as it were. Maybe I'm wrong, but if our party is progressing now, up to the point of being able to contest the election the way we did, and then you must expect that not quite a number of political parties will be happy with us, and they will do whatever to ensure that we are not able to hold hands and then provide to the people of this country ultimate dividends of administering them politically. And I think the sentiment is right, and I believe in it strongly.
All right, COMRADE OGBALOI, Labour Party Chairman, Edo State, thank you very much for your time. We truly appreciate you.
Thank you so very much.
It's still politics today on independent television and radio on the ITV network. We'll take a short break. We'll be back with our panelists in the studio to look at the recent judgment by the Supreme Court on the Osun State governorship election, some of the key points, and then the implications of those points. Stay with us. Many thanks again for rejoining us on Politics Today on ITV Network. It's a simulcast because you can also follow the program live on our radio platform, Independent Radio, and you can follow us live on our website at www.itvradionnigeria.com. ntvradio.ng.com. Let's welcome our panelists once again, Barrister Sonny Daudu and Pius Iwo. Thank you again for coming. The Supreme Court has finally nailed the coffin in Osun State as it relates to the governorship election confrontation, so to speak. But let's look at the key points raised in that judgment by the Supreme Court and the implications of these key points for subsequent election tribunals that are ongoing, without necessarily mentioning the name, so it doesn't look like, because already the matter is sub judice, as it were, or as you guys say it. So let me start with you, Barrister Sonny Daudu. What are your findings as it relates to that judgment by the Supreme Court on the election petition tribunal in Osun State?
Well, these are personal views, and I believe that they may represent a vast majority of views in respect to the elections and the outcome at the Supreme Court. To me, the popularity of Adeleke cannot be questioned. This is not an issue of party. It's not an issue of whether or not it's a party of PDP or APC. If, without mising words, I have stated it here before now, even the first elections were won by Adeleke, wherein we used to later ruled. Adeleke won the elections. Again, it showed clearly the second elections where he has seated your incumbent. I would have expected that Yusula would have accepted it in good faith without even challenging the elections at all. When the tribunal gave a judgment that technically removed or temporarily seemed to have removed Adeleke, some of us expressed reservation over the judgment. But again, we were happy where the Court of Appeal restated him, and that again was affirmed by the wise men of the Supreme Court. And if the Supreme Court has taken a decision, it has laid the matter to rest. And that is the position of the law.
Okay.
They were not based on sentiments. That decisions were well reached, well articulated, well evaluated, because the evaluation of evidence before the court showed clearly that Adeleke won the elections. And again, if you look at the decision, some of us raised this even in our normal discussions, where the court allowed the tribunal, allowed himself to be bruised by the dust of litigation, by attacking the person of the governor Adeleke when he was bugai. Lo. So to me, I do not think
yes,
that was even necessary in the first instance in the tribunal, because you have led the issues and be attacking
getting personal,
getting that personal with the governor elect, that the man is dancing everywhere. What concerns he got with the dancing? I think the Court of Appeal and the Supreme Court has written the wrong of the tribunal. Okay, we are happy with it.
All right, let me get your take, because the issue of beavers, the issue of election. Yeah.
Well, the judgment of the Supreme Court, first of all, the Court of Appeal and the Supreme Court did not give particular consideration to the comments made by the tribunal on Buga or Lololo, whatever, as it were. Of course, our modern day judgments are seen to be, of course, there will be nothing wrong with having a judgment being progressive, as it were. But we must appreciate the take-home from the judgments of the Court of Appeal, which was now affirmed by the Supreme Court of Nigeria. And I would take a few minutes to analyze that judgment of the Supreme Court. First of all, the Court of Appeal affirmed by the Supreme Court. Let's start with the tribunal's decision. Well, the tribunal's decision would have been otherwise, but you recall that the judgment of the tribunal was a split decision. 2 out of the 3 judges of the tribunal decided in favor of Oyetola, and it was a judgment that I foresaw was certainly going to be set aside on appeal at the Court of Appeal, the way it is now. And this is the drama that played out. The in that decision, which started from the tribunal, then to the Court of Appeal, and then the Supreme Court, the potency of the beavers machine was in focus.
Okay.
And we realized that, first and foremost, you recall that the Osun election was the first test for the 2022 Electoral Act, that's amended Electoral Act, which, of course, we saw the potency and then the efficacy of the beavers machine as passed by the National Assembly. And in that decision, in consideration of that case at the tribunal, the certified true copy of the beavers accreditation data report was given to Oyetola by INEC. And now, they used what they had to approach the tribunal. And their complaint at the tribunal was, one, that there was overvoting in the 744 polling units in Osun State. And the second leg of their consideration, their petition before the tribunal, was the qualification of Adeleke Ademola. Of course, that did not go anywhere because the Supreme Court, the Court of Appeal and the Supreme Court had nailed that matter before now, when the issue of whether Adeleke forged certificate or not was brought before the tribunal in the first election that they did, I think in 2015, 2016. Now, the issue in the tribunal haven't had the advantage of being the report, the data report, the beavers accreditation data report tendered by Oyetola, proceeded to also, after hearing the respondent, which is Adeleke Ademola, those ones also tendered their own, also from INEC.
Okay.
So the problem was from INEC. There was a misconception. I mean, there was a problem which INEC caused, and we wouldn't have found ourselves in these murky waters in Osun State. INEC issued an interim report to Oyetola, the data report. And it was a clerical error. They should have indicated interim report of data report. And when Adeleke Ademola came, they also tendered what was given to Adeleke Ademola was different entirely from what was given to Oyetola.
Was that an interim report?
The one given to Adeleke was not an interim report. It was a final report.
Okay.
But why given to Oyetola, they didn't indicate it as interim. It was a clerical error. Now, both were secondary evidence because they were certified true copies of the report. At the point of INEC, the umpire that conducted the election, of course, they have a duty to confirm and to state their position as to what justified their granting, of course, declaring Ademola Adeleke as the winner of the election. So what played out? They proceeded to bring the original beavers machines to the court. And it was observed that the beavers report, the beavers itself, the report was consistent, the accreditation was consistent with the votes cast.
So there was no
overvoting. There was no overvoting. So the tribunal fired wrongly. They aimed wrongly by giving consideration to the first report, which was an interim report, and said, oh, look, that interim report, the subsequent report may have been procured in anticipation of the trial, and that perhaps those were altered or whatever.
Okay.
But the Court of Appeal had an opportunity of appraising and looking at this, and using the best evidence rule. In law, of course, tendering and admissibility of documents in our courts are governed by the Evidence Act. That where the best evidence rule is the primary evidence. And what was the primary evidence here? The original beavers machine, as they were tendered. It showed accreditation was done and they were consistent with the results declared.
All right, Mr. Sonny Daudu, quickly give me your take on this issue of beavers, because I know that even in the presidential election, that was a major talking point in the conduct of the election, particularly the aspect of sending results through beavers to IREV, and there were a lot of interpretation to all of that. Has this judgment laid that contradiction to rest, as it were?
Of course. You know, the beavers, what actually played out in the last elections, when people were arguing as to whether or not INEC must immediately transmit results through the beavers to the IREF. I think it was also a misconception. The beavers, even without network, can store all the results. Even when sent, they may not deliver, but they remain in the beavers. Because the beavers can work off and online. Now, if you look at the decision of the court now, is that it is immaterial whether or not the results were transmitted immediately. Once the results are confirmed that they were not altered as contained in the beavers, the court will appeal them. It is immaterial what comes out first. It is immaterial whether it was not even sent at the time people were complaining.
Okay.
But once, because at the point of accreditation is at the unit level, it's not whether or not the results were actually transmitted thereafter. The question is that what was accredited, what was voted at the units level, is it what is now before the court? Once that's the position of the court will not, the court must affirm, because it is that beavers results. What is inside the beavers, as he has said earlier, is the primary result. And that is the real evidence. Once you have the real evidence, every other issue is actually secondary.
Okay.
All right. I think there is need for me to respond to also, to lend my voice to what my brother has talked about.
Yeah.
Let us appreciate the judgment of the Supreme Court, the Court of Appeal and then the Supreme Court. The issue of transmission of results was never an issue before the Supreme Court.
In this
Adeleke's case.
Okay. Yes, it's not.
It was never an issue.
Okay.
So the court has not made pronouncement on that. It is the issue of accreditation, the beavers accreditation data report.
Okay.
You see, from what we have seen in the tribunal, both in this Osun experience, the days of vote or don't come to vote and we start on printing and you just declare results, the days are gone, they are over. There must be evidence of accreditation. And the accreditation will show from the beavers report that will be tendered, because both parties will rely on the beavers report. We're not talking about the result now. The results must tally with the accreditation. And when that is done, it settles it. So, by and large, the point that has been made, which Oyetola took to the tribunal and went straight to the Court of Appeal and the Supreme Court, was the issue of overvoting. And how do you determine overvoting? You must rely on the beavers accreditation data report and compare it with the results declared. Do they tally? If not, then there is a problem. But in Osun experience, Adeleke's report as presented to him by INEC and the one tendered by INEC were consistent with the results declared in favor of Senator Ademola Adeleke. Okay. Yes.
All right. I've heard someone like, I'm trying to remember, one of the senior advocates of Nigeria saying that the Osun State governorship election judgment by the Supreme Court is a two-edged sword, which could have far-reaching implications, even for some pending election matters, even at the Supreme Court, or even up to the Supreme Court, depends on where they are right now. Do you subscribe to this?
You know, if you look at my earlier submission I said the judgment has a far-reaching implication. It is immaterial whether or not the issue of transmission of result was canvassed. The issue of whether or not the beavers were used for accreditation and whether or not the results that were transmitted align with the beavers is an issue. It's immaterial whether or not it was canvassed in Oyetola. Once the court agrees that what was accredited with the beavers is what gave birth to the results that the parties have. That settles the matter. So to me, once it is confirmed that the Beavers is in line with the election declared, the issue of whether or not transmission was done earlier will not arise. That's what I'm saying. Because if you look at it, it's a sister case actually to issue of whether or not you must transmit, and if you do not transmit immediately, whether there is an issue. That's what I'm saying, that even if it becomes an issue canvas there, once the court is satisfied that what was done through the Beavers by virtue of accreditation is in line with the total results declared, when you cumulatively look at the parties, what they receive by the various parties, APC, PDP, Labour Party, and all of that, NNPP. Once you look at it, it's in conformity with what the Beavers captured for the purpose of accreditation and voting. All other issues are secondary to it, because the Beavers is what will determine whether or not the results from the various units are in compliance with what the Beavers, of course, released, and what was the results also declared at the national. Because when you have collated results, maybe from the units to the ward and the local government, maybe to the senatorial districts as it were, or the state level, and that again is now taken to the national for the purpose of announcing it. The question is whether or not the results received from the local governments, from the units, are in tandem with what was discussed at national. What it is that any other issue regarding whether elections were transmitted immediately will not arise. It will be deemed as a secondary issue. That's the position I'm trying to make. Okay. Again, if you look at the Electoral Act in respect to Beavers accreditation and all of that, you will see that there is a synergy of ensuring that even in the absence of immediately seeing the results, there is also a minor coalition. That's why all political parties have what the constitution room.
To monitor the election.
To monitor the election. And what does the situation room does is that once elections are done at the unit level, there are agents at the unit level forward it to the situation room. So even before you announce results at the national, the political party already have their results, because they have agents at the polling units. Again, when the results are moved from the polling units to the ward level, the parties also have coalition agents at that ward level. So once it is collected there again from the ward level, the results again is transmitted as a result from unit 5, for example, I'm sorry, ward 5. Then when you take it back to the local government, maybe local government A now, they also have coalition agents at the local government coalition office. So when the results also cut from the local government, it's also forwarded to the situation room to show that in local government A, the party A has this, party B has this, party C has this. So even before taking the results to the central, all the political parties already know what they have.
Okay. I think what we have seen in this Osun decision is that the Beavers, the potency of the Beavers has been restated. For a petitioner to succeed in an election petitions tribunal,
Beavers is key.
Beavers is key. The Beavers, you see, the politicians who go about trying to manipulate the process or try to rig do not know that there is something there.
Yeah, because we see here things like go to court. Yes, go to court.
But unfortunately,
is that changing?
Somebody, yes, the Beavers is there that will determine whether the results tally with the accreditation or not. And when that is done, for God's sake, the petitioner would have succeeded in coasting home to victory in such a situation. But looking at the presidential election, this tribunal sitting in Abuja, and the allegations, or do I say allegations, or the petitions as contained, presented by the various political parties, you realize that they are not, apart from the issue of transmission of the result to the IRF through the Beavers, which they complained that INEC did not even comply with its own rules, its guidelines,
electoral guidelines.
Yes. Yeah. They have raised some other very germane and fundamental issues, which we are awaiting the Court of Appeal, which is sitting as a election petition presidential tribunal to determine. And that is, they've raised the issue of the 25% in the Federal Capital Territory as a requirement by the Constitution. They've also raised the issue of qualification
I think on the 25% requirement, some residents of some indigents in Abuja have gone to court to challenge the swearing of the president.
Yes. So because it is within their powers and their right to do so. Okay. And then they have also gone, if you look at, take time to appraise the petitions presented by Peter Obi Labour Party and then Atiku Abubakar of the PDP. Though they tend to overlap in some respects, but there are
areas where there is a convergence.
Yes, and that there are areas that the Court of Appeal is invited to also look at, apart from the conduct of the election itself. Okay, that is the area of qualification, like I talked about, and then the area of non-compliance, and then some other things. The area of course, it talks about the qualification, the issue of qualification of the president-elect to have conducted, contested that election.
Let's take a look at. Let's open our studio line so you can also call and be part of the program Politics Today on ITV Network. As we always say, please endeavor to be civil and be brief so that others waiting on the line can take their turns and contribute to the discussion today on the program. Our studio line is open now. Just dial it and make your contribution right now. Right away, 080 77770300. I'll take that again, 080 77770300. You can dial the number right now and be part of the conversation. Let me just get you on this. The Supreme Court held that Adeleke needed not to have even contested this matter in court.
Defended.
Yes, defended this matter in court, as it were. I'm just wondering, what is the ground for such a statement?
No. Once a suit is filed against a person, you must go and defend it. It doesn't matter whether or not it's watery.
Okay.
The position of the law is that where a person is aggrieved, he files an action in court, the person against whom the matter is filed in court must, of course, defend. If such statements are made, it's just specific. It's made by the wayside. They are not really that he should defend the matter.
Okay. I think what the Supreme Court meant by that statement, and I agree with the Supreme Court, is that the allegation by Oyetola was actually against INEC. The conduct, what INEC declared, what INEC did, and not against Adeleke, as it were. So it was something that Adeleke needed to come and say something, or is coming to say anything, will not change what Adeleke has presented as his petition before the tribunal. It is something that INEC had the responsibility to answer, and that is the discrepancy that we've talked about the Beavers report, accreditation report, that was data report that was presented to him, and then that presented to Adeleke, which were, of course, for which we saw disparities. And then when INEC now later came in defense of the petition to bring the original, which is the primary evidence, the Beavers machine, which the tribunal, of course, glossed over, but the Court of Appeal said, no, look, this is the primary evidence. And in law, the best evidence is the primary evidence. And having presented the machine, the Beavers machine, of course, the tribunal did not look at those that were presented before.
Okay, let me quickly take this call. Hello, caller. Good morning. What's your name? Let us know where you're talking to us from. Good morning. What's your name? Hello, caller. Good morning. What's your name and where are you calling from? It's Policies Today. It appears we lost that call. And yes.
Let me straighten the point.
Yes, stress the point quickly.
The law is very clear in respect to where matters are joined as a party. Once you are joined as a party, Adeleke was joined as a party.
Okay.
It's not his party now, as in PDP. Once you are joined as a party in any suit.
Just a moment. Hello, caller. Good morning.
Yeah, good morning, sir.
Yes, tell us your name and where you're calling from.
This is Emeritus Comrade SOS from Igara.
Okay, from Igara. Go ahead.
Sir, you see, the bottom line, we are all graduates. The bottom line of the whole matter is that the INEC should wake up and be very much alert to their responsibility. What are we doing? We cannot buy fuel. Somebody approved this person for 8 years. And then we cannot see light.
right, thank you, caller. We just needed to make it brief so that others can take their turn. 08077770300. Good morning, caller. Tell us your name. You're live on the program. Go ahead with your contribution. Good morning. Please endeavor to turn down the audio level on your television or radio to remove the echo. Good morning, caller. Yes, good morning. Go ahead, please. Yes, go ahead. Turn down the audio level on your TV or radio to remove the echo. As soon as you do that, we'll put you back on 08077770300. That's the number to call. Let us know your name and where you're calling us from, and please ensure you turn down the audio level on your TV or radio. Good morning.
Morning, Duke.
Yes, tell us your name and where you're calling from.
This is Sonny Yadosa.
Okay, Sonny Yadosa, please go ahead.
I want to beg those who are leading us in this country, especially from the various political leaders, or political party, individuals, private organizations, and others. They have become a role model, and they have become pace setters. Remember, you have been in this state long enough. You knew how COMRADE and Judgement were removed from office, and it started from his words. Even some people that didn't like it from that party, they all joined in the suit to ensure that it was removed. Now, I feel very disappointed or not happy when somebody went to court and you are saying that the person that court removed, you said that is your party chairman. I think we need to be very careful because some of us are listening to some of them and we admire them for over 15, 20 years. And we are hoping to learn from them. When you make this kind of statement, it seems that we do not have regard for the judiciary or for the court. That's why if you look at your guests in the studio, even though they have their reservation, they are very careful. Because it should not be seen that the law of the land is not respected. I think the best the Labour Party people can do are not happy. It should go back to appeal court, see what they can do. Then if the suit is not satisfied, they can go to Supreme Court. Maybe at the end of the day, if there is no favor there, they either go to heaven or go back to their village. Okay. But to come out in a public court and begin to...
All right, so I'm thinking perhaps there's an aspect of that conversation that you're probably not familiar with, which will also help in your contribution by way of analysis. You heard the Labour Party chairman, and when he said that he's very certain that ab initio, the party did respond to that issue, that suspension that came up from the ward. And if they did, the lawyers here told us that they were quite in order, and that should be a platform for them to, make demands or take, their position as far as the leadership of the Labour Party is concerned. That's very, very key. But we're limited by time. Yeah, we're limited by time.
Thank you very much.
Yes.
I follow you when you started. And you know the guests you have in the studio, they are one of the persons that I enjoy listening to.
Okay.
The point I'm saying is that there are young people who are listening.
Okay.
They asked a young boy on your program one time ago, this RTV, he said he wants to become a politician.
Yes.
Please, let's teach our people so that they will be good politicians and not become rebel in our society.
All right, thank you.
Good morning.
Thank you. All right, I just quickly answer the point.
The point I was driving is that the law, the position of the law, is that once a person is aware or perceived that a matter is filed against him, it's immaterial whether or not the matter was it or you must defend it.
Okay.
Once the delegate is named as a party in the suit, he must file his defense. Because again, the decisions will have an adverse impact on him, whichever way it goes. Even though, of course, they said it's meritorious for him.
All right. Our time is up, gentlemen. Thank you very, very much. Our package for today on the program, Politics Today on Independent Television Network. I want to say big thanks to our panelist, Barrister Pius Oiwo. Thank you for coming.
Thank you.
And Barrister Sonny Dawo, thank you for coming. Earlier, we interfaced with Comrade Kelly OGBALOI from Abuja, who joined us via telephone. Thank you for your time with us. Do have a lovely weekend. Be sure to join us next week, Saturday, same time, same station on the ITV network. Politics Today. Have a great